Thank you, Vice Chair Bernal, members. Thank you so much for staying so late for our state's children. I'm Paige Duggins-Clay. I'm the attorney and chief legal analyst at IDRA. We respectfully are here today in opposition to House Bill 6. My written testimony has outlined 5 specific provisions that we are concerned about, and they've been discussed at length. I want to say, the Chair Leach is not here, but I want to say thank you. His office has been exceedingly generous and open in having a line of communication, and has been really receptive to feedback, and so I want to express our profound appreciation for that. I want to spend my time just focusing on a little bit of context. First, there's been a lot of emphasis on due process, and to the extent that we are considering some of the fairly draconian measures in this bill that are really emphasizing removal and longer-term isolation of young people, we have to balance that with student due process. We have some ideas for that and hope the office will be open to that. We also, for example, want to see limitations on in-school suspension to the extent that we're going to adjust that timing. Just leaving it open-ended is a really unacceptable status quo for our most vulnerable children in particular. In addition, we have profound concerns about the idea of virtual DAP. We understand the intent, I think, is to provide us another option for students and families, but we'd like to, again, see some safeguards put in to make sure that that intent is captured. And we've also heard testimony today which echo our concerns about the use of the word disruptive. It is a very subjective term. And look, I have a 6-year-old and a 3-year-old. I'm an expert on disruptive behavior by young people. But we really want to see, to the extent that what we are talking about is violent, aggressive, unsafe behavior, we really want to see specificity so that if removal is happening, we're acting on it. The last thing I just want to share is just some context. We mentioned correlation, causation, but in addition to some of the policy changes that happened, I don't want members to lose sight of the fact that we have failed to invest in special education funding. We have failed to raise the basic allotment since 2019, resulting in this current teacher shortage. We have experienced an era of mass school shootings and targeted school violence and a global pandemic resulting in a mental health crisis. And we can't discount these factors.
Thank you very much.
Fix in the bill that you think are at odds with engaging parents and respecting their rights that we should look at seeing if we can change?
So, Representative, if I may also just flag one other provision that hasn't been talked about is the codification of the HONIG provision. And so I just want to point out that this is really the provision that allows for judicial removal of students by filing a petition in now state court as opposed to federal court. We really view this as an access to justice issue because in those cases, the schools, right, are going to have attorneys who are representing them, supporting them, guiding them, and students and families do not and will not. And, you know, they already don't get advocates or counsel in already overly complicated Chapter 37 and school discipline proceedings, and now we're pushing them into court and really exacerbating that imbalance of power. So that's something that we really urge this committee to look at.
I'm sorry, I forgot your name on the end.
Me?
Yes.
Paige Duggins-Clay with IDRA.
Okay. And you were concerned as well with the civil action part,
Yes.
correct? But I'm just speaking as a teacher, and I taught special needs students. I had a student who was mutilating and killing animals, who was locking grandmother up in a closet, and doing some very aggressive behaviors. And, I mean, people were scared. And it says in here, before that civil action is taking place, they do a threat assessment. And the school is making reasonable efforts. And so, you know, we get criticized all the time in school that, well, you knew something was going on with that kid and you didn't do anything. You waited all this time, and then he ended up hurting himself or hurting another student or a teacher. So how do you balance that when you have a really severe student who is doing very bad behaviors that we know, mutilating and killing animals, leads to more violent type of activities? I mean, there's a pattern there, and that would be part of the threat assessment. And I think that's a legitimate part to consider. So, I mean, we're trying to stop things before they happen. And if we don't, then we're criticized for that. So how do you balance that? I mean, you don't wait the frustration for teachers is people waiting till something happens when you knew all along this kid has got some dangerous behaviors.
Yeah, thank you for the question, Representative. And it's a fair question. The situation you described is obviously an emergency and a serious incident. So I want to flag a couple of things. First, the threat assessment process is good law, and it is being done in place. There's been some work by this committee on that provision very recently. And so following the recommendations of the Threat Assessment Committee are really, really important. And one of the things that the Threat Assessment Committee can recommend and that the school leadership can do is actually remove a student on an emergency basis because there is a threat of harm. And so our position is that Chapter 37 is, as it was pointed out, 150 pages long. There are many places in law that already provide for a teacher to remove a student who might be exhibiting those problematic behaviors from the classroom. And really what we're focusing on here and what the legitimate debate about today is about what is the appropriate setting where we're going to provide the interventions and support to stop this really harmful behavior. And so one path, which is in this bill, the specific judicial removal proceeding, is pushing kids into court. And I'm an attorney, I've represented kids in this context, and I've also represented schools. And I can't think of a time where involving courts and even state courts really expedited matters and where there was not as much expertise as we have developed in our school settings, where that has really made things better. So I think that is really concerning that we're overlaying yet another layer of policy and law and bringing in actors who may certainly want to do right by students and children, but courts have robust dockets that involve a lot of really complicated issues. And so I think we might be, flooding courts potentially and ultimately shooting ourselves in the foot a little bit by trying to push things out when ultimately the expertise and the support we need is here. And then the last thing I will say on this point is, to the extent that removal is the solution that, our school leaders are asking for. Look, I'll be the first one to say, I'm the daughter of a teacher, generations of them. Sometimes behavior is really serious, and for the health and safety of students and peers and colleagues, we gotta, remove them. But that removal can't be indefinite. That removal can't violate federal law and federal civil rights protection, which I'm concerned that going to state court is intended to circumvent the federal due process standpoint. There are others who can speak more to that, but my limited experience raises some concerns about that. And I think you all just need to look at the data. I mean, Chapter 37 is 30 years old this year. And we've been using zero tolerance methods, right, of suspending, of expelling, of using JJAPs for a long time. And those methods just have not worked. We are using them now. There are more students in DAEP now than were even in 2021, sort of coming back from the pandemic. We are suspending students. We are putting students in truancy court. So I just want to flag for the committee that that's a consideration as well.
I think some of the difficulty for schools, though, is in the case, and that's what this is sort of addressing in this section, is when the behavior is linked to the disability, then schools are very cautious in removing a child, and they've shown that they've gone through all of the reasonable efforts. I wouldn't think that it would be unreasonable at some point to have a court back you up in that when they're saying, well, this behavior is linked to disability. Okay, well, it might be linked to disability, but it's still violent. It's still dangerous.
Yeah, we're in total agreement about if there is a violence and there is a safety issue, we have to act, and we can't be second guessing ourselves in that, in those circumstances. But the advocacy on behalf of students and families with disabilities is not going to go away just because you pushed a family into court, right? But you've changed the balance of power, I think, and made it into a setting where there's going to be less expertise, less familiarity, and yet another sort of layer of policy that we're all going to be navigating. So my point here is that to the extent that the goal is to get at very specific targeted behaviors like violence, like harm, like some of the horrific stories we've heard today, I think we can get there and talk about that. Our concern is that language like disruptive, Some of the other things that might get swept in and pushing kids into court is really concerning to us.
But do you feel like, we haven't gone down this road yet.
Sure.
But do you feel like, or at least I would feel like, that a civil action would also somewhat protect a school district when they have tried to do the right thing by the student, and they've tried all of these reasonable efforts. They've done their threat assessment, and having a separate set of eyes, the number one lawsuit for school districts is special education lawsuits. So I would think that that would somewhat protect them
It's a fair
because it's
question.
another person going, okay, we're coming up with the same conclusion. Yes, this child needs to be removed. When you have that extra layer of it linking to a disability.
It's a fair question. I think the two things I would say are we ensuring that we are not using this new state court process, because there's already a federal court process that is established under Supreme Court precedent to sort of pursue these, and schools do them. So is state court the appropriate place for that? Is there sufficient expertise for that? And are the costs worth it, the protection? And I'm saying this as an attorney, no knock to my profession, but in my experience, it's rare that bringing in attorneys to student discipline and all these things, I mean, it balloons the cost of this thing where we really could be focused on the interventions, investing in the things that, you've heard from testimony the last 2 weeks, and even today from our amazing superintendents talking about the resources and support that we need. I think that would be a better focus and priority in investing in SPED funding and raising the basic allotment than pushing in a court system that necessarily is going to increase costs, because you got to have litigation fees and costs and lawyers to represent schools and families in those cases.
Okay, thank you.